Hi, my name is David Taylor with Twin Falls Estate Planning, and a question I get a lot is what's the difference between a will and a trust? Now, the problem in answering that question is that usually ends up being a 5-minute conversation and I lose someone's interest in about 10 seconds because it's a bunch of legal jargon and that's what attorneys do. So I'm going to share instead a story that just demonstrates the difference. The main thing to know is that when you do a will, you are directing the probate court, meaning when you pass away, there's going to be a lawsuit. Actually, I tell clients when you do a will, your audience is the judge. You're writing it so that the judge can oversee the court proceedings. So what could go wrong? Well, let's find out. So this involved a couple who did a will, and to be honest with you, it was a very well-crafted will, right? Looked great, all the terms were in there. It could probably take the will and hang it up on a picture because it looks so good, right? So husband and wife create this will, and the first one to go is husband. A little insensitive, but we're gonna take care of him because he passed away. And pursuant to the will, when one spouse passes away, here's what's going to happen. 1/3 is going to go to the surviving spouse. 1/3 of the assets are going to go to their children. And then 1/3 of their assets are going to go to their grandchildren. I don't know why they did it that way. I'm sure they sat down and talked with an attorney and for whatever the reason decided that would be best, but nonetheless, that's why we did it. But what happened was the surviving spouse looks at this scenario and thinks the same thing I did. Why did we do this? Why don't I just take all of the assets and upon my death, then I'm going to give out half to the children, half to the grandchildren, whatever it is. And all of the children agreed. And they said, yeah, that sounds good, Mom. Let's not complicate things now. But here's the problem. How do you change something that's already in effect? Because the will says when one passes away, here's what happens. Well, here's the way you change it, is you have to get everyone on board and everyone to agree that that's going to be the new plan. Where's the problem? The grandchildren. And why? Because they are minors. So in a court proceeding, a minor cannot represent itself in the court proceeding, meaning the minor cannot agree to the new established plan. This involved a lot of work. What ended up having to happen is we had to appoint what's called a guardian ad litem. So we had to get and hire someone else outside of all of these people to be a third party, an intermediary, someone who is going to represent to the best of his ability the grandchildren's interest. And that person then had to receive all of the information from the court. He had to make an agreement and he had to appear in court a few times to make sure that he was certified and able to take care of the grandchildren's interest. Now, the solution, if instead we had done a trust, number one, this would have fallen outside of the court, so there would have been no judge nor court proceeding, no guardian ad litem, because we would have done what's called a trust protector. And a trust protector is one who can change the terms of the trust so long it is in all of the beneficiary's best interest. That sounds a lot simpler than having to go through a court proceeding, having to appoint someone outside of the entire process, pay someone to represent the grandchildren's best interest, and so on. So if you're considering a will or a trust, and especially if you're thinking of giving anything to minor children, you should be concerned because it would likely be a lot better to put things in a trust to avoid having to go through probate and avoid all this process.